Good morning, Your Honors. The matter before the court this morning is the case entitled Deborah Tarrant versus Christopher Bartels and Amelia Bartels, case number 25 AP073. Representing the appellant, Deborah Tarrant, is attorney Pietra Lynn. Representing the appellees, Christopher Bartels and Amelia Bartels, is attorney Hannah Waite.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first. Please start by introducing yourself and your client, and then proceed.
Yeah, good morning, Your Honors. My name is Pietro Lynn. I am representing Deborah Tarrant in this case. She is the successor in interest to her now deceased husband, Richard Tarrant. Some of you may know Mr. Tarrant. In any event, this is a case that arose from a home owned by Richard for many, many years in Colchester. What I'd like to do is orient the court to what this layout is. There are four lots, or originally four lots, that were issued and sold by Marble Island Inc. This is on Mallett's Head in Colchester. And the four lots start at lot number 3, which eventually turned into a home owned by a Mr. Brickman and later sold to Dr. and Mrs. Gennari, and then eventually to the Gennari's daughter and son-in-law, the Bartels, who are the appellees in this case. The lots go from south to north, 3, 4, 5, 6, 7. What we know is that Mr. Tarrant purchased lots 6 and 7 for a home in the 1960s. Eventually, he built a home there. Dr. Gennari and his wife purchased lot 3 from a Mr. Brickman, who at the time owned 3 and 4, the lot to the immediate north. And that's significant, judges, because that's really the focus of this case. It is a case where there is a claim of adverse possession. There is a small strip at the south of lot 4, which is the area that is the subject of this appeal. The matter went to the Superior Court, and Judge Hoare issued a decision claiming or ruling that there were no questions of fact in the case and finding for adverse possession. Now, as the court well knows, it is a heavy evidentiary burden for a party to claim and succeed in an adverse possession claim. That can only happen where it is clear that the party has engaged in what is a continuous and open and notorious and obvious use of the land contrary to the interests of the owner. What we see here is anything but. What we understand is that this small strip of land, 30 or 40 feet wide, about 60 or 70 feet long, was that there was a small piece of driveway from the original home established by Mr. Brickman that extended onto a piece of property that he then at that time owned, small area of driveway. There's a claim that over the years there was a rock stairway that was built on the side of a hill on this parcel of property, and that games were played like croquet on an area on this small strip of land that was grassy. Also, at some point, a leach field was buried under a small portion of this property. So if the question becomes whether there was open and continuous and notorious, let's start with open and notorious use of the land, we would suggest that, if anything, the evidence here is that there was not. That this small area, this strip of land on a fully wooded parcel of property that Mr. Tarrant bought for the express purpose of creating buffer, an area where he would not spend any time, there's no evidence he ever did, an area that was wooded, an area that nobody used except for this small portion which was used by the Tarrants. So was that open and notorious? We would suggest to you that at worst, there was a question of fact. And why Judge Hoare concluded there was not is very difficult to understand. He found that as a matter of law, that there was ample evidence of this open and open and notorious use based on the fact that there was use.
You have 1 minute, counsel. 1 minute.
Thank you. I guess I will defer until my opponent is finished, and then I'll do my one last minute.
Okay. Thank you very much. We'll turn to counsel for the appellee. Please start again by introducing yourself and your client, and then proceed.
Good morning. May it please the court. I'm Hannah Waite, and I'm the attorney for the appellees Amy and Chris Bartels. So as your honors know, this case is about adverse possession. And before getting into the nitty-gritty of the arguments here, if there's time for that, I wanted to take a step back and offer a quote from a Supreme Court case, Jarvis versus Gillespie, which is a case cited by both parties in this matter about adverse possession. And what that case said was, the ultimate fact to be proved in an adverse possession case is that the claimant has acted toward the land in question as would an average owner, taking properly into account the geophysical nature of the land. So with that legal background in mind, if you'll indulge me, I'd like to paint a picture for you. So it's 1979, you're moving to Vermont and you're lucky enough to get to see a house on the lake to potentially buy. You drive down a narrow one-lane, pretty long driveway down a hill. And at the bottom of that driveway, you see a flat paved parking area. The parking area is there so that you can turn around and get back out the driveway rather than trying to back up. And beyond the driveway is a wooded area, and that wooded area continues in a relatively straight line down towards the water. And if you look to your left, you see there's a little hill and there's a lawn there. The lawn continues from the wooded area right up to the steps of your home. You can walk from the lawn up the steps to your second story porch. And the land is bounded on the north by this clear line of trees. So you buy the house, and almost every day you use the driveway. Almost every day you park your car in the turnaround, you turn yourself around so you can get back out. You have parties for your kids, you rent a bouncy castle that you keep on that flat area. You park an RV there for your grandchildren to sleep in every summer. You ultimately put a septic field in under the lawn. You put in some rock steps so that you can walk from the driveway down to the lawn. You plant perennial flowers on those stairs every year. You have parties and you have weddings on the lawn that's by the lake. And eventually someone on the other side of that wooded lot builds a house, which you can see in the distance. And then that person comes to you and they claim that you don't actually own this property that is adjacent and contiguous to your home, that's always been part of your home, and that you've always used as if it was yours. And in fact, you thought it was yours. So I think that this is the case that the doctrine of adverse possession was established for, and that Jarvis is referencing. There's an important context for the procedural posture that we are in here. And that context is that no one disputes that that is what the Generi saw when they drove down the driveway. And no one disputes that that is the use that has been made by the Generis and then by my clients since that time. They use the land the way that any owner would. So the arguments by the appellant in this case essentially distill to a claim that this case is just not appropriate for resolution on summary judgment, that you just can't make it. Adverse possession claims are so fact specific that you just simply can't decide them on summary judgment. And as you'll see in our briefs, I think it absolutely is appropriate. I will admit, and I can't contest, that adverse possession can be very fact specific. And there may be cases where one party claims that they drove a plow on a field every day for a year, and the other party says, I looked out my window every day and I never saw you driving that plow. Or I claim that I use this driveway every day, and the other party says, you're only here in the summer. There's no way you use that driveway every day. Those are disputes about material facts of use that would need to be decided by a jury, but we don't have those types of disputes of fact here. And the question of how those undisputed facts apply.
You have 1 minute, counsel, 1 minute.
Thank you, Justice. The questions of how those undisputed facts apply to the law is certainly something that the court can decide. And I think the Superior Court reasonably engaged in that inquiry. And I'll just make one last comment. I think that the appellant would like you to think that the amount of use in the disputed area was small. I think that there's a quote in their brief where they say they only used a quote a few square feet. And I would encourage the justices to look closely at the map that's provided on page 7 of our briefs to see just how much of that space was really used regularly, continuously, open and notoriously by my clients. Thank you.
Okay, thank you. How much time does the appellant have, please?
Appellant has 50 seconds remaining.
Counsel?
Yeah, so I think it's important to remember that the key here is that there must be a showing that a person of ordinary prudence would have been on notice of these claims. And whether in fact that is satisfied or not is really in the end going to be a question of fact. As you know, in the cases that we cited in our brief, there things like erecting fences, moving and clearing brush can be insufficient. A driveway encroachment as here, planting trees, those all can be insufficient. Underground tanks might be insufficient, like a leach field here. And so the issue really here is not whether ultimately a finder of fact would conclude there was adverse possession. The issue is whether the judge can take that issue away without any evidentiary hearing to support the ultimate conclusion. And what we would urge you to do is remand this, have the issues heard in front of a finder of fact, and then we can get a decision about whether the elements of adverse possession were or were not satisfied.
Okay. Thank you very much. Your time has expired. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for